the obligations in this case.
But counsel, there's a difference here. And that's the reason why the court's asking. Judge Alf signed a coordinated discovery order. Counsel, any questions on this witness?
Yes, Your Honor.
Thank you.
Valerie Rojas, 322. Good afternoon, Mr. Kemper.
Good afternoon.
What are your duties and responsibilities as the Vice President of Administration?
On a day-to-day basis, I'm responsible for fuel supply in 4 states. I also work on retail pricing on a daily basis. I am part of a development committee. I sit on a board of an association. I have various different tasks.
Do you have any duties and responsibilities with respect to information technology?
No,
Do you have any education or training in information technology?
no,
Prior to signing those original responses to interrogatories, did you have an understanding that Mr. Rudolph conducted a company-wide search for emails?
I was the one that asked him, so
And
yes,
do you believe that he did perform that task pursuant to your instructions?
absolutely.
And did Mr. Rudolph locate any emails, communications, or agreements between Terrible Herbst and Real Water?
No,
And as we heard earlier, and what you understand, Mr. Sexton also conducted company-wide searches for emails when he arrived at Terrible Herbst, is that correct?
I don't know if it was right when he arrived, but it was sometime during his working.
And is that because you wanted to confirm Mr. Rudolph's work before giving your deposition testimony?
Well, it was my belief that Brad, with his wealth of knowledge and background, that I was being safe in doing a secondary search just because I wanted to make sure, 1, and 2, that was prior to my deposition, and I wanted to make sure we were covered in that sense.
Prior to signing the original interrogatory response that Mr. Parker showed you, did you undertake efforts to make sure that others conducted email searches?
I did.
When you signed the verification form for the original response to the interrogatory concerning communications with Real Water, did you believe it to be true and accurate?
Absolutely.
Were you trying to hide anything when you responded to that interrogatory?
Absolutely not.
Earlier, when Mr. Parker was questioning you, he was repeatedly using the term willfully, and you agreed with him on a number of occasions, including that you willfully signed certain documents. When you agreed that you did something willfully, did you mean that you intended to sign the document?
Yes.
When you used the term willfully, did you mean to imply at all that you had lied or misled somebody?
No.
When you signed your declaration, each one, I believe there were a few that Mr. Parker showed you, did you believe those to be true and accurate at the time that you signed them?
Absolutely.
And at the time you signed each of those declarations, were you aware of communications with Real Water?
No.
Were you aware of any contracts with Real Water at the time you signed your declaration?
No.
The time you gave your deposition, were you aware of any communications between Real Water and Terrible Herbst?
No.
Did you believe the responses you were giving in your deposition were true and accurate at the time you gave them?
Yes.
And I understand that now that response is no longer accurate, correct?
That is correct.
Did you supplement that response
I believe so.
since then? Mr. Zamora, can you please have the supplemental response to interrogatory number 6 brought up? If you could please scroll down To the next page, please. Is this the supplemental response to interrogatory that you, interrogatory number 6 that you verified?
Yes,
Okay, if you could please, and is this response accurate currently?
yes,
When you say yes and describe communications?
yes, it's correct.
Do you know who Amy Jones is before you saw the email?
No,
Do you know who Brent Jones is?
no,
Do you know who Blaine Jones is?
no,
Do you know who Anthony Randolph is,
no,
other than what you've heard here today?
correct.
Do you believe you've ever had communications with any of those individuals, whether by email, telephone, in person?
No,
Earlier, there was some mention of a rebuilding of a server. Do you recall Mr. Sexton taking a number of days from his normal duties in order to rebuild the server?
yes,
So does that refresh your recollection that as part of Mr. Sexton's efforts, one of those efforts was to rebuild the server?
so in my deposition, I believe we talked about that, and yes, that had to do with, the servers, for the emails and the I'll call it the credit card, data, that we were asked to, produce.
And did Terrible Herbst undertake that effort in order to locate as much information it could concerning Mr. Hunwardsen's purchases?
Yes, and that was when I talked to Brad, I believe he told me it took him, I think, 5 or 6 days with 3.5 people. And I said, like, 8-hour days? And he said, yeah. I said, okay.
And did you personally participate in rebuilding that server?
No,
And you mentioned earlier some, after Mr. Sexton conducted his company-wide searches with no results, that he searched your emails. Do you recall that testimony?
I do.
Do you recall Mr. Sexton contacting you in order to gain access to your emails?
Yes, absolutely.
And then do you recall a second contact in which he contacted you to advise that he was now out of your computer?
Correct. And I think what that is about, if somebody remotely goes into your computer, I get an email that says, hey, somebody's in your, it's a security feature. So he wanted me to know that I'm going to get that email, and then when he gets out, the email comes again that says whoever it was is now out.
Okay, so I was incorrect. The email comes from, it's an automatic.
I believe it's an automatically generated email for security purposes.
Where were you physically located when you received those notifications?
Right back there in that back row.
In this courtroom?
Yes,
And did that occur last week?
yes.
And after you discovered, well, let me ask you this. When Mr. Sexton was searching your emails last week, did you understand that he was searching the online archive?
It was my understanding he was searching the online archive, along with anything else and everything else.
Did you personally have to search your online archives?
I have not.
Did you rely on Mr. Sexton to search your online archives since you've been here?
Yes,
After the searches of the online archives and the results that bore out, did Terrible Herbst locate any written contract or agreement with Real Water?
no,
And am I correct in understanding your testimony that any agreement concerning the 2020 coupon or payment for those bottles would go through Nevada Beverage?
correct.
Was Real Water the only product on that 2020 applause screen?
No, there's multiple products. I think they, maybe up to 6, maybe 3 on one side and 3 on another.
So when the applause screen pops up on the digital prompts at Terrible Herbst, it gives a selection or options for the customer to choose, is that right?
Absolutely, yes.
So in other words, it's not just real water being displayed on that screen, right?
No, we usually have at least a cup of coffee and a fountain drink. Those are always in there, and then there's other products within the store.
And the other products that are on the applause screen online coupons, would those products be Terrible Herbst products or products from other manufacturers?
They're all other manufacturers.
And including, for example, Anheuser-Busch or other water products?
Correct.
Does Terrible Herbst have agreements or written contracts with each and every manufacturer that it creates a coupon for that product?
No.
Mr. Kemper, if you had learned that the emails located last week had been discovered sooner, would you have authorized their production in this Hunwardsen case?
Absolutely.
Were you attempting to hide anything from this court or anyone in this case when you responded to the initial interrogatory number 6?
No.
Did you intentionally try to mislead anyone or hide anything when you signed your declarations that we went through today?
Absolutely not.
How long has Terrible Herbst been in Clark County?
My understanding is 1959, and then I think it was incorporated in 1964, doing business as Terrible Herbst Inc.
Okay. How long has Nevada Beverage been in Clark County, if you know?
If my memory serves me correct, somebody told me maybe in the 40s. I think they reached back before the Herbst family.
Do you know the family that owns Nevada Beverage Company?
I don't know.
Do you, how long have you been at Terrible Herbst?
A little over 30 years.
Since your time at Terrible Herbst?
Well, let me rephrase that. I worked for the Herbst family for over 30 years.
And in your time in working for the Herbst family for over 30 years, has Terrible Herbst always had a distribution, say, informal agreement with Nevada Beverage?
We've never had a written agreement, if that's your question.
Okay, but has Terrible Herbst always worked with Nevada Beverage since you have come to Terrible Herbst? Or to
Yes.
work with the Herbst family?
Yes,
That's a long-standing relationship?
absolutely.
And to your knowledge, has the Herbst, or Terrible Herbst, ever had a contract or written agreement with Nevada Beverage Company?
No.
To your knowledge, has Terrible Herbst ever had a written contract or agreement with Real Water?
No.
Has Terrible Herbst always, when it did purchase Real Water, purchased that through Nevada Beverage Company?
Correct.
So am I correct that any financing in terms of payments for coupons or for the actual product itself would be between Terrible Herbst and Nevada Beverage?
Correct.
Thank you, sir, that's all I have for you today.
Thank you.
Means by agreement of the parties, thank you so very much for your time. Feel free to step down and go to whichever seat you're otherwise occupying in the courtroom or whatever you'd like to do.
Thank you.
Okay, thanks so much. Well, at this time, counsel, realistically, from a time standpoint, in order to ensure that you get the other motions done for today, I'm going to have to limit you each to 10 minutes for closing arguments. If you want up to 10 minutes of closing arguments. Because realistically, I have to go back to you all's agreement that this was going to take no more than 3 hours, including whatever arguments you wanted to do. Allowed you to extend it way past them, but in fairness, there's another motion pending, and there's demonstrative exhibits that have been brought up by Mr. Odou for the last couple of days with regards to, so that, in fairness, to get them all done without having members of the veneer panel having to wait yet another day. So, Counsel for Plaintiff, feel free to go ahead, and I'll tell you, I know what the court's question's gonna be to each side, I can tell you what it's gonna be.
Go right ahead, John. I think I have a
If
suspicion.
both sides want it, I'll tell you. If one tells me not to tell you, then I won't.
Yes, Your Honor.
Okay.
Yeah, no worries.
But the court's question really is going to refer back to the question that I asked Mr. Sexton. It seems to me that you all are saying that this is a straight Microsoft Office suite, and I just need clarification on that. There's no modifications, which means it shows up on the left-hand side of a computer as one of the folders. And so that's going to be the court's question is going to be, to your knowledge, is it that standard suite or something else? And that's going to be the question to both sides. Go ahead, please.
Your Honor, Mr. Sexton, to answer the question directly, when Mr. Sexton was testifying, my IT person, Mr. Godfrey, came up and said, that's nothing separate. It's a part of the Microsoft system.
Wait a minute, are we getting new testimony here?
We're not getting new
That's not new
testimony from
testimony.
either
I'm
IT.
asking
No. I'm asking to you all's knowledge for purposes of this. And I can appreciate you each have tech people behind you. This court's really to you all's knowledge, because you all looked in preparation for today's evidentiary hearing. You looked at the witnesses, you looked at the other information, you looked at deposition, some things that you may not have presented specifically during the evidentiary hearing. No, we're not opening up to new testimony because realistically, people aren't on the stand.
And Your Honor, I appreciate the question. What I would ask the court to take a look at, and I know why the court has the question, first, if it's part of their speech, which he said it was, it should have been easily recovered, number one. Number two, which I think should be very apparent to the court, there's nothing in the opposition that mentions this issue. The declarations don't mention this issue. In fact, Your Honor, the letter we received, which is a part of the briefing that we received from Cozen O'Connor says, during searches for documents responsive to Henry, request productions using the term drinkrealwater.com, in quotation marks, I understand that Terrible Herbst located emails from 2019 that may be relevant to Hunwardsen were located. It's right here, Your Honor. As you may have seen from the previous declaration of Terrible Herbst employees, the search term previously used did not include drinkrealwater.com, but rather variations of real water without the drink, and may not have captured an archive. We are working to produce any newly located documents potentially relevant to the Hunwardsen case today. Your Honor, this online archive issue, in terms of being something separate and remote from the Microsoft system they're using, is contrived. This is what we got, and the declarations we have don't even mention it. The declaration that was given to us by Mr. Kemper in the opposition to the renewed motion doesn't even mention it. Mr. Sexton's declaration doesn't mention it. No one mentions that. The only thing that's mentioned is the way they searched in terms of the search terms. That's it. This new position that they've taken today is not reflected in the four corners of these documents. It's simply not. Your Honor, what we do know, and I know the court is familiar with these cases, so I'm not going to put them back on. And I want to reserve a couple of minutes on the public, so I'm not going to use all of my 10 minutes right now. What we do know, Your Honor, looking at the Valley Health Systems case, and to me that case is probably the closest in terms of identifying witnesses. That court said, based on the evidence this court considers to be clear and convincing, Centennial intentionally and willfully violated its discovery obligations under NRCP 16.1 and failing to timely disclose that nurses Murray, Wolf, and Samara possessed relevant and material evidence relating to the central issue in the case. No one in that case came up to the stand and said on an evidentiary hearing, we willfully did it. The court can take it from the conduct. What we know is we have 4 declarations that were false. They've all admitted it on the stand now. Actually 5, because even Mr. Kemper had 2 declarations. We have 2 false deposition testimonials, Mr. Kemper and Mr. Breed. Your Honor, in the CCSD Richardson case, there were only 2 false affidavits. We have 5 declarations that are false, sworn under oath, sworn interrogatory responses under oath, and 2 depositions under oath, all false. There is not a single case the Nevada Supreme Court has decided, ever, that had this many discovery abuses in it. Your Honor, Mr. Waite said something that I thought was very dismissive when he said, he analogized this to Alice in Wonderland, suggesting this is either a comedy or some whimsical issue that we brought forward. Your Honor, I can't imagine the court seeing something this bad in terms of discovery abuses and sending the message to every other litigant or practitioner that this will be condoned by the court. When you continue looking at the prejudice discussed by the court in Valley Health Systems, the court said there were no lesser sanctions because there is no way to fix this. We've started trial. We have a jury impaneled now, and all of these things came while we were picking a jury. There is no way of fixing it. There's no way of redoing motion practice, depositions, written discovery. It is impossible. We've spent millions of dollars in time in this case, and there is no way of fixing it. Every factor under Young Rivero points in one direction. And I'd like to, like I said, reserve 2 minutes to address Mr. Waite. I don't believe I need to go over all of the factors. I think we did that in the first time yesterday.
Just one reason to give consideration for the time period. The court does have another question though. I'm going to ask the same question to both sides.
Right.
Was there, as you know, the rules require during the early case conference that you must engage in what is going to be your ESI protocol if you're going to have ESI protocol. At least from what you all told me at other hearings, is there is a depository for these coordinated cases for discovery. Was there a discussion on the ESI protocol with regards to document searches, documents being produced separate and apart from specific discovery requests?
You know, I have 1 second
Sure.
to respond to that.
And in fairness, if any side needs somebody else to answer the question, I think it's fair I can let somebody else answer it, because I am appreciative that different attorneys may have come in. Mr. Parker, you may not be hearing it. If Mr. Parker wants to answer it directly, he could. The same thing I'm going to offer to ETT, because if Mr. Waite's doing the oral argument, I can appreciate Mr. Waite was not in this case earlier on. And so he may have to ask somebody, you may need to ask somebody because somebody else is doing it. So if I do it equally to both sides to answer the question, are you all fine with that?
Okay, we're good with that, Sean.
Okay, I'm not requiring it, I'm saying you can say it as well, I'm trying to be fair to everyone, I know there's different people being into this case at different times. Go ahead, Mr. Pepper.
Mr. Pepper, can I-
But you just need to have a microphone, there you go. We don't have your wall today, but go ahead.
Yes, Your Honor, thank you. In September of 2021, I believe we had a special master hearing regarding the preservation of evidence and the disclosures, initial disclosures under 16.1. This issue was discussed. There was no request for any particular ESI protocol at that time. My recollection is primarily because it's not that complicated in terms of anything beyond what is normally required under Rule 16.1. So the issue of disclosures and evidence preservation was raised. There was nothing discussed about anything abnormal, anything special that needed to be done beyond what the rules already provided. The special master order required all initial disclosures, all parties to make their initial disclosures by October 2021, with the exception of plaintiffs' medical records, who were still in the process of collecting some of those, and we were dealing with a confidentiality issue with the HOLO depository. The HOLO depository was set up. There was a special master order regarding the creation of the HOLO depository. Everyone was ordered to make their disclosures. To that, there was no specific requests or anything abnormal regarding ESI beyond what's required by the rules. Those disclosures were made. We relied on those disclosures. We made follow-up discovery requests, and I think the court is aware of what happened since then.
Thank you. I'm gonna wait till you have your chance to give yours, okay? But I think you're about to have your chance, so thank you, that was the answer to the court's question. Go ahead, counsel, for ETT.
Thank you, Your Honor. Dan Waite for ETT. Let me address the court's questions first in reverse order. If I understood Mr. Pepperman correctly, I agree with him from the standpoint that I'm told that there was no special ESI protocols in the court-dated case.
And I'm offering you the same opportunity if somebody else needs to answer it directly, that's perfectly fine. It's whoever wants to answer it,
I
okay?
just had the opportunity to consult. So turning to the court's first question that you posed to, I think it was Mr. Kemper. It was a good question.
Mr. Sexton.
Mr. Sexton. It was a very good question, Your Honor. And it was a good question because it demonstrated, the answer demonstrated that the product that was being used was not something that was developed unique for Terribles, something that they might have had some special right or responsibility to know the ins and outs of a product that they had specially designed for them. That wasn't the case. It was a standard, I don't know, but it seemed like it was an off-the-shelf type of a product. But the important question here for today, Your Honor, which for purposes of willfulness and so forth, is what Mr. Sexton believed that was being accomplished with his searches. In other words, his willfulness, it regards, did he believe that the searches were all encompassing? And in fact, everybody testified. Let me just back up to the top, Your Honor. And I think the backing up to the top starts with, we have to keep in mind whose burden it is here on a motion for sanctions to strike answers and these types of things. Clearly, the burden is on the movement. And a couple of points of Nevada law, because as it relates to the Young factors, Your Honor, I believe I'm correct in saying what was the purpose of the evidentiary hearing here today focused primarily, if not exclusively, on the first component regarding willfulness. And in the MDB Trucking versus Products Company case, 136 Nevada 626, at page 632, a 2020 case, the Supreme Court indicated that willfulness requires, quote, more than negligence, end quote. In that same case, the Supreme Court says it requires, quote, an intent to gain a litigation advantage and harm one party's opponent, end quote. It is the plaintiff's, the movement's burden, plaintiff here, to demonstrate that evidence was destroyed or by extension was not disclosed with the intent to harm. And that's the Bass-Davis versus Davis case, 122 Nevada 442 at page 448, 2006 case. And as the court said in both Bahena and Foster v. Dingwall, striking an answer for discovery abuses often involves behavior that is, quote, repetitive, abusive, and recalcitrant. Your Honor, there's much that I could say, but keeping to the time constraints and perhaps even trying to finish a little bit early, I'll just simply say plaintiffs here in this evidentiary hearing presented no, obviously they called witnesses, but they were all witnesses that were our employees, all associated with us. They did not present any witnesses of what I'll say, their own witnesses, which is just a way of saying every single witness that you've heard today testified under oath that they had no intent to deceive, to misrepresent, to gain, to hide or to mislead. And for this court to determine that there was willfulness to hide, to mislead, and those types of things, the court will have to disregard the testimony of every single witness that you heard today, because there was no contradictory testimony. You'll have to find that each one of them lacked credibility such that their testimony that was very specific, that Ms. Rojas brought out, was unbelievable. There is no contradicting evidence of those. Ronald, I'm just quickly searching, and again, mindful of the time. Did I answer your questions, or do you have any more questions?
I will, but I was going to let you finish whatever your argument was, and I was gonna ask you a
Okay.
question on MDB trucking with the duty of preserve. Okay.
I'm sorry?
No, I was gonna wait till you finish, then I was gonna ask you a question at the end.
I'm glad you mentioned something about preserve, because you heard Mr. Parker talk about witness disclosures, okay? And again, when you look at the corners of the motion, there's no mention about failure to disclose witnesses. I'll go back to my argument yesterday morning. Under the rule, under 16.1 as it currently exists, and the Valley Health case, it's not under rule, it's a 16.1 case, but it's not a 16.1 case under the rule as it currently exists. We are not relying upon these documents, and therefore there was no affirmative obligation to produce these documents. You still have not heard and had pointed to you a Rule 34 request for production of document that any of these documents were responsive to that should have been produced. But that does not deal with, going back to my argument yesterday, there still is the issue of misinformation that was provided in declarations and deposition and so forth. And so the question is, what is the appropriate remedy for misinformation that by all the sworn testimony was not intentional? It may have been negligent or whatever, but I cited you the case that that's not sufficient. But what is the remedy for that? Are the monetary sanctions? There are certainly lesser sanctions. I'm not going to go through the whole list that we talked about yesterday. But the question for right now is the, sorry to use the off with their heads analogy one last time, is that the appropriate remedy here and now in this instance? And I would suggest to you that it is not. With that, Your Honor, you have a...
I do have a few. Okay. One is, you made a reference to MDB trucking, right? And I know
Yes.
that's spark plugs and other things, pre-litigation for routine maintenance, right? That's what it says.
Yeah.
Read straight from it, right? Over the course of the next year, before any lawsuits were filed, MDB mechanics performed routine maintenance on Koski's rig. The mechanics replaced at various times a plug, 2 sockets, and a damaged cord that were part of the electrical circuit controlling the Versa valve. They also replaced a second cord associated with the electrical circuit controlling the rig's lights and anti-lock brakes. Leaving them irrelevant, MDB's mechanics discarded the plugs, sockets, and cords they replaced. So that's different, is it not? Because that's pre-litigation routine maintenance versus here, and this is one of the court's challenges, so it's gonna be a longer question, is everyone agrees there's a duty to preserve documents when you're known for litigation. That's a legal obligation. Here, in order to have effectuated that legal obligation, it is very difficult for this court to put its arms around the concept of that nobody looked to see if exhibit documents existed. And therein lies a very large challenge for this court because that's an affirmative obligation. And there's an affirmative obligation to preserve.
Yes.
And in order to preserve, you've got to check with the various individuals to have them preserved. But this court has not heard anything from any of the witnesses that anyone bothered to do anything before 2023, with the exception of some of the testimony of Mr. Kemper with regards to the interrogatories in 2022, right? But nothing before. This litigation you all know the date on the complaint, right? It's 2021. And whatever pre-litigation because of other cases. And there you go back to why I was asking the question about the ESI protocol, right? And your depositories is even before the actual filing of this litigation, the concept of real water was surely known by anybody who had, let's say, I don't think Terrible is going to say that they didn't know before 2021 about claims of real water because you have a recall, and they definitely did. Okay, and then you have litigations already starting. Okay, so I'm getting to my question. So are you contending that it in no way relates, it's claims and defenses? It's not just plaintiff only has to do their claims and defendant only has to do their defenses. Are you contending that there was no obligation by Terrible Herbst to retain the documents that related to the claims at issue at the time of the complaint, which did at that time include both strict products liability and negligence-based claims? Because that's what it sounds like what I'm hearing is like, well, because they don't think it's any parts of their defenses, they didn't need to bother about these documents and provide them, but independently they'd have the duty to preserve. In order to preserve, they have to do a search to know what to preserve and to tell all the appropriate people to preserve. And so, are you contending that they have no obligation to provide documents that relate to plaintiff's claims?
If I understand your question,
It was a long way of getting to the simple part of, are you contending the Terribles had no obligation to provide any documents related to plaintiff's claims?
I am contending that under the version of Rule 16.1 that has been in existence since 2019, there is no obligation on a party to affirmatively produce documents that are that your opponent may rely upon to support their claims or their defenses.
So if you walk that one through, right? And I was thinking when you said this yesterday, you paraphrased it. In essence, then are you saying they could destroy?
No, that's an
Documents?
entirely different issue.
Okay,
Laura.
but that's why the court's going to this, right? That's why the court's long-winded version till I got to the actual question portion was tying in your response to MTV truck and the duty to preserve. How does one preserve documents if you don't look to see what documents to preserve?
You don't destroy documents, Your Honor. And by not destroying them, you, by virtue, preserve them. You put a litigation hold. That's the whole purpose
But
of
what are you
litigation
putting a
hold.
litigation hold on?
You put a litigation hold on your files that are relevant. And I don't disagree that requires perhaps either a system-wide hold that preserves. But I do have to say this, Your Honor. There's been nothing. This is not a preservation case. This is not a spoliation case. This is not an alteration motion, fabrication motion. This is a late disclosure. And that begs the
Late
question.
counsel, and I'm hearing what you're saying, but to say late disclosure when it's in the middle of jury selection really kind of
Okay,
does
really
not go
late
with, does
disclosure.
not go with the concept of a general late disclosure. That's a few days, a week, a month. That's not years later in the middle of trial.
But it begs the question, Your Honor, of was it required to be disclosed in the first place? The only discovery response, I'm setting aside for a moment, can I finish?
Sure.
I'm setting aside for a moment the misinformation in the declarations and the deposition, focusing on the documents themselves, which I believe is what you were focusing on, okay? They have to tie that those documents that were produced, not in this case, but in the companion case or the other case, the Henry case, that there was an obligation to produce them here. Because if there was no obligation to produce them here in the first instance, there is no such thing as a late disclosure of a document that you never had an obligation to produce in the first instance. I mean,
But counsel, walking through yours, it really does, the reason why I was asking the destruction question is because if you don't have to produce it, so how would, let me phrase this a little bit different. This is coordinated discovery, correct?
that's my understanding.
there are specific obligations of the parties in coordinated discovery to use a document depository, correct?
That's my understanding.
Okay. So if you have coordinated discovery, then you don't necessarily look at the specific case. You have obligations, right, to put into the document depository documents that relate to any of these coordinated cases. Correct or incorrect? Is that, I'm just trying to see your position. I'm asking your position.
I'm gonna pause there because I have heard Your Honor say numerous times in this case and in other cases that you're only dealing with what is before you. And that is this case and the discovery and so forth that was propounded and the obligations in this case.
But counsel, there's a difference here. And that's the reason why the court's asking. Judge Alf signed a coordinated discovery order, right? And the scope
You're
of that,
referring to the CMO.
no, CMO's a Special Master Hale.
I know, we
Judge-
got it adopted, but I just.
No, we're talking two different things. Okay. Let's go back.
I don't mean to get it sidetracked,
No
Your
worries,
Honor.
no worries. But I'm gonna, okay. Before the CMOs, on May 11th, 2021, there's a document that was filed in this case, right? A stipulation in order to coordinate cases for pretrial discovery purposes only under NRCP 42 and 250. On page 2 of that document, it includes the Hunwardsen case. And this court has to know about it because it gives the scope of what this department is doing versus what is the coordinated aspects, right?
Understood.
Okay. So the reason why the court's asking the question, unlike different examples that you're referencing, is those cases did not have coordinated discovery. Meaning, I look at the case before me, I look at the case before me. It's a distinction if I'm looking at something that's coordinated for discovery purposes, because then it has a big global concept. I'll take a case outside of this case. Let's take a construction defect case in a hypothetical sense, which has got like fourth party practice, et cetera. Everything gets put in there, and there's different things. There may be coordination with other cases. They may not be consolidated because they may be the same homeowners grouping in a particular development, but they may not be consolidated. They're coordinated, but for ease, you have all your destructive testing and everything put for that, okay? Taking now to here, I'm not gonna go to DOT because you got one of the parties here in DOT. I'm taking cases that don't involve, right, okay? Now you go to this case, there is a stipulation in order to coordinate discovery, signed by Judge Alf. It's filed on 5/11, signed by her, should be the same date on 5/11, okay? And the notice of entry thereof was shortly thereafter, okay? So that document controls discovery, it controls coordination of discovery. So unlike an individual case, right? And unlike a consolidated case, because 3 separate sets of rules, right? The coordination is governed by the scope of the coordination order. But the coordination order, and that's why I was asking everyone's understanding with the ESI protocol, right? Then ends up with so it specifically says paragraph 6, although they involve separate and distinct plaintiffs, individual personal injuries, and some unique defendants, the real water cases all arise out of similar factual circumstances, and pretrial discovery will involve common questions of law and fact. Paragraph 7, coordinating the real water cases for pretrial discovery purposes will promote judicial efficiency and avoid both unnecessary costs and potential conflicting decisions on common issues. Before you got into this case, Hunwardsen, there were statements made about depositions done for multiple cases that applied to all the cases under the coordination order of Judge Alf, which does apply, and this court has to abide by it, because she's a low number judge, low number case, okay? At the time. Okay, and what I mean by at the time, there's been certain cases consolidated into that, including one of these departments, but that's a non sequitur. So, in a case where there's coordinated discovery, the court's question was focusing on this case, because this case is a case as part of coordinated discovery. There's obligations, are there not, or if you disagree, I'm just trying to get your position on this, on behalf of ETT, that you have to provide things that apply to all the coordinated discovery cases, because this is coordinated for discovery by the pure terms of the order entered into by Judge Alf back on 5/11/2021. Do you agree or disagree, or maybe you don't know because you got into the case later?
Your Honor, I cannot articulate a position, both because I have not been able to review, I've reviewed a lot, I hope that's somewhat obvious, but I have not reviewed the May 11, 2021 Judge Alf order. Someone else might be able to speak to that. But second of all, that order has not come up at all in these proceedings that would cause me to, or my client to, in this motion. There's no mention about that there was an obligation to do anything under the court's coordinated order.
Why would they? Why would
Because
they? Because it's an order of the court, it's law of the case, I have to follow it. And that's where I'm seeing this differently. Fully different if you're talking about a pure, like a two-party or three-party independent case. But here, what this court has to look at, right, I have to follow law of the case.
Sure. And
I have to follow an order by Judge Alf. It doesn't matter that she's now retired, she still was the judge at the time. Department 27, now it's a Department 15 case, but those are irrelevant issues. But I have to look at that for the history, right? Because I have to go to what are the obligations? Because your client is asserting, right, that he did not have an obligation to produce certain things under, I understand you're saying, your interpretation of a plain language of post March 3, 2019, NRCP 16.1, correct?
I believe so, Your Honor. I didn't quite follow that.
What I'm understanding that you're saying is that this court has to look at this under whether or not these documents needed to be produced pursuant to a discovery response, that the court should not be looking at under the eyes of a 16.1 disclosure issue.
I understand that.
Is that that's your contention, right?
I am saying that these documents were not required to be produced under 16.1 or any Rule 34 request in this case.
Which is why this court was stating that doesn't the court have to look at it differently because of the coordination of discovery issues and the global obligations of the parties. And I was mentioning an example that had been brought to the court in a prior hearing, and that was regarding a deposition, whether or not a certain deposition that was taken after discovery was closed in this case, but it was basically for coordination discovery, could be utilized, okay? And then it was the issue about whether or not ETT got to participate in said deposition, and if they did or did not, and whether or not it could be information utilized in that deposition because of their participation, right? So that's why this court keeps on going back to the coordination order. It was a stipulation in order, so it wasn't even just a straight order. It was a stipulation in order that specifically says this case is covered in it. And that's why this court, when I'm hearing your statements, I can understand how they would apply to potentially, I'm not saying it does or doesn't, but could potentially apply to a generic case that is not coordinated for purposes of discovery. But here, since there are discovery obligations that are coordinated, which is being utilized in multiple cases, I was asking you, doesn't that change the analysis of what needs to be provided for purposes of this case number of Hunwardsen pursuant to the coordination order? And I appreciate, you may not have been expecting that, but I have to follow it because it's a coordination order and that's law of the case.
And therein, Your Honor, your last statement is where I would like to address.
Sure, go ahead.
But let me first start by saying, if you feel that dispositive to a resolution of this motion depends on that issue, then I would suggest that needs to be briefed. But let me back up for a moment and address your earlier comments, and that is the parties and the court has to follow the Nevada Rules of Civil Procedure. The parties and the court have to follow the 8th Judicial District Court rules, and there's probably other things out there. But when a party brings a motion to the court, the party chooses how to frame the motion and the relief that they want and to invoke what rules and laws and so forth that they want to undertake. All that I was saying, forgetting for a moment the substance of the order because I haven't read it, I can't address it. No one prior to Your Honor just a few moments ago raised that consolidated order. And so we're at a distinct disadvantage I'm certainly at a disadvantage of trying to address something that the parties did not raise. And so if that's dispositive, then I would suggest we need to brief them.
I am gonna give, since I asked you the question, you said they haven't raised it. And I'm going to see if opposing counsel agrees or disagrees with the statement that it was raised or not raised for purposes of the motion to strike.
And if they claim that it was, I would ask the court, ask them the point where.
I'm doing the open-ended questions, same thing as I asked you. Mr. Parker, not go afield on other issues, just be narrowly on the whether or not the coordination of discovery issue is addressed within your motion to strike before the court.
Your Honor, we didn't specifically raise it because we'd have to raise everything as a part of the law of the court, the law of the case, Your Honor. Every deposition that we've discussed already. We've had this conversation several weeks before Mr. Dan Waite appeared in this case. We had those discussions during the motion practice that lasted almost 2 weeks about depositions being used in this case. In fact, we had depositions taken after the close of discovery in this case that were referred to in this case because they're all a part of the same case. The court's right. One other thing I would mention,
I'm
Your
only
Honor.
asking questions.
Okay, I know. It's somewhat inflammatory when I hear Mr. Waite talk about arguments not raised, when in fact, that 16.1 argument about the change in the law, I don't believe that was necessarily raised as a part of their opposition. Your Honor. So, but with that said, Your Honor, I want to touch upon how appropriate.
Okay, so now you're going from the court's question to utilize your last 2 minutes. to
Exactly,
finalize
unless you want another
your
question.
Well, that's
before
fine,
we
I'm
address.
just making sure we've got it clear because
Oh, yeah.
you can't go far afield from the court's question, but if you're utilizing your last 2 minutes to do your summary, then you can.
Unless there's another question the court has for me.
I do not at this juncture.
Okay, Your Honor, you raised this point that it could not be more central to the decision in this case. You said, isn't there a preservation obligation? Think about that.
I didn't raise it. Counsel mentioned MDB trucking and Bass versus Bass Davis. He raised it.
He did, and
I didn't raise it.
and you differentiated between preservation and production. Your Honor, think about this. If they had preserved the information, then they would have known those communications were out there, and we wouldn't have 5 false declarations, 2 false depositions, and 1 false set of interrogatory responses. Because they had an obligation to preserve it, review it, and then answer accordingly. That's something they didn't do. Mr. Waite talks about willfully, determining whether or not these discovery abuses were willful. Going strictly to the Valley Health case, and this part of 16.1 wasn't changed, even if they had raised it. It said, simply put, Centennial's management was aware of the knowledge of numerous Centennial staff. Again, we're talking about failing to identify witnesses of various stations, like Ms. Adams, Mr. Breeden, and exhibited an unlawful pattern of suppression and denial over the course of years to the plaintiff's detriment. This is under the Centennial's misconduct was determined to be willful because of that charge. This case is so on all fours when it comes to our present circumstance, Your Honor. If they had preserved, as they should have done for all consolidated cases, or even just this case, they would have known that their declarations were false. And when you talk about using those declarations, that they were not willful, they used them to fight off and ward off our motion for summary judgment. And they used it as a sword in their own motion for punitive damage, John. They knew what they were doing. They did it, and it has put us in this horrible position, severely prejudiced, with no way of recovery. There is, when you
Can you
look at,
walk me through your prejudice? I mean,
oh, sure, Your Honor.
I mean, I'm hearing what you're saying, but I'm walking through where the case is now, right? Because
Yes.
now I have to, because you're asserting prejudice when you no longer have negligence-based claims, you have products liability claims, and the current posture of this case is damages only and the potentiality for punitive damages. So can you walk me through how
Absolutely,
you're saying that you're prejudiced?
Will do. In fact, Mr. Godfrey, please put up the prejudice slide, which is slides 35, 36, and 37. And it should be on your screen now.
Right, where I'm trying to do the nexus to what is actually left for the jury to decide that you're saying you're prejudiced on. I get the global concept, brand new documents coming at the time of trial, okay? There's an inherent prejudice in that concept, but walking through this case specifically, same thing I said to opposing counsel, right, is you've got the amount of damages in a variety of types of damages, right? And it's not any advance rule, I'm just saying, I have to look at this, because you all wanted this one first, I have to look what the current status of the case is.
That's correct.
So what is the prejudice? If you had these documents, what would be different for purposes of your presentation for trial that you can't do now? You can-
Absolutely.
Go ahead.
Thank you. First thing is, the witnesses, had they been identified, we would actually depose them during discovery. That's number one. We've not deposed several of these witnesses, because we weren't aware, we're still not aware of all of them, because we still haven't gotten, for example, Kayla Adams has not been identified in this case. That's number one. The emails between each of these people, we still don't know to this day whether or not there's emails out there. Mr. Sexton admitted that the ones he personally took an interest in were the 4 that he identified for us. But he's not done that same exercise with everyone else. We know that for a fact, and Mr. Breeden testified about 5 others that we don't have that information on. All of these documents, all of these witnesses, the depositions we could have taken, would have gone to our punitive damage claim. There's, in fact, if I could pull it out, I explained to you. There, when I said
And you have to
there,
realize, sometimes I ask questions, I may know the answer, but I need to hear it
for
from
the
you
record,
all
absolutely.
to have an
not.
understanding of what we're contending.
There is, and it's better to see it from them, there is a conclusion in the brief by ETT that tells you why punitive damages, this was in their motion for summary judgment against the plaintiffs for summary judgment. And their motion, the conclusion is here, page
If you turn
34.
those pages right there with that mic,
Oh,
they'll get your
I'm sorry.
page turn in the transcript, so you just probably want to move that up on top a little bit.
Will do.
Yeah, thanks.
If you could turn to slide 24 for a quick second for me, Mr. Parker. This is out of, right above the conclusion to ETT's motion for summary judgment as to punitive damages. I'm sorry, this is their opposition to our motion, I apologize, Your Honor. Opposition to our motion initially. All of these things that they said have been proven to be incorrect, Your Honor. They used those same declarations I was saying earlier, and I apologize, saying earlier, in support of their motion for summary judgment on punitives. They were saying because there were no relationships, there were no communications, there was no complicit working together between Terrible's and Real Water, that they could not ever be held responsible for punitive damages. That, if you can recall, I know that was eons ago now, Your Honor. So when we argued that motion for their motion for summary judgment on punitive damages, that was their claim to fame. There's nothing, all we did, to use their words, I believe, taken out of their brief, all we did was sell the water. Someone else delivered it to us and we sold it. That was their position. Now we know, based upon the documents we've seen just recently, that they were complicit in their marketing strategy, in the promotionals, in the commercials. All of these things were going through, now we know at least 290 pages worth, that all of this was happening before. We didn't know this, we didn't have all that information. All we had was small bits and pieces. We know a lot more just based on the information we got last week. And unfortunately, we can't incorporate that into any of our trial work at this point. It's impossible. We can't get it into the witnesses, we can't take the additional depositions, we can't re-argue the motions, we can't give it to experts. There's no way of incorporating it into our trial, because it's impossible. We'd have to let this jury go for a year and bring them back and start all over again. It is impossible. They have forfeited their right to do this on the merits because they prevented us from having the merits on this case. Your Honor, we have done everything we could, and remember when we argued that motion against their motion for summary judgment, how they made it clear to this court with those declarations that this was some remote relationship. They never wanted to concede that there was a partnership, and we learned through these documents just last week that there was a partnership, that they were designated as a terrible supplier partner. I would have loved to take depositions to find out what is the criteria for becoming a partner. How many products do you have to sell? How many promotionals do you have to do? We don't have any of that information. But we know that some of the big wigs like Anheuser-Busch was also a part of that partnership. Your Honor, it is, when you look at every Nevada Supreme Court case on this subject, I challenge this court to find worse circumstances in terms of discovery abuses. I don't think
Or
you
you
can.
can't ask me to do
I'm-
that. You have
I'm
to
saying-
present it to me what your concept is, counsel.
Your Honor, I'm saying that only because I've shown you that the last time, I don't want to spend all the, I've shown you every case, I believe. I showed you Valley Health, CCSD, Bohina, every one of them, and I compared the discovery abuses to this one. And I don't think you can get worse circumstances. And certainly plaintiffs couldn't be more prejudiced than they are.
Let's circle back.
Yes,
Appreciate
Your
the
Honor.
factors, John Rivero. Okay, and you've quoted 37, okay, in your pleadings, John Rivero. But for case terminating
Go to 33.
sanctions,
Go to 33.
you quoted it in your pleading,
Yes, Your Honor.
because you did it right above the John Rivero. Does anyone disagree that they quoted in RCP 37?
We agree that in their motion, Your Honor,
Yeah, they did.
they did quote 37.
So remember, while the MDB trucking is a destruction of evidence case, it goes to the concept of the willfulness and the harm and the prejudice for case terminating sanctions overlapping with the Young versus Rivero factors, right?
That's correct.
It does have a language, as it requires, cites to Bass Davis, requires an intent to gain litigation advantage and harm one party's opponent. And there it was destroying material evidence, but you're in essence saying the destruction concept is the fact, failure to provide till the time of trial.
Your Honor.
So
Right.
if I'm looking at that, how do I see a litigation advantage that they would be trying to gain when I have to look at this case as being damages only? And that's not anything negative in saying damages only, it's just, right, based on the current status of the case.
That's correct. Then that's why I read into the record what came out of Valley Health Systems. The court decided the central issue was the one that they made them affirm the district court's decision on striking because of the witnesses' knowledge, the nurses, and the witness statement. Those statements weren't lost. They were still available. The actual nurses were still there and available. But one of the things they pointed out that goes directly to prejudice was the fact that over time, memories fade, and I'm sure you remember reading that in the holding, Your Honor. In this case, which is similar to Valley Health and Richardson, CCSD Richardson, the documents weren't destroyed. They were, in Richardson, it was in trial. In Valley Health Health Systems, it was provided after the fact. But they weren't destroyed. So when you look at this case, under that lens, one of not destruction, but abuses in terms of discovery, preventing one side from being able to have a case decided on the merits, you go right back to what has happened here.
But then are you saying that there's a lesser standard than willfulness?
No,
And
I think willfulness under the Valley Health System is what I told you, what I read into record a few moments ago. The pattern of the discovery abuse satisfies the willfulness prong or factor under Young Rivero.
So when you're saying discovery abuses, you understand, you know, calling your esteemed opponent, opposing counsel, whatever, is saying that there was no document requests in this case. There was the interrogatories that were answered, and you referenced 6, and they changed, they filed a supplement, was it January
Last
18th
week.
or whatever the date was, but it's close, with our starting jury selection. But for the willfulness, for your purposes, we're saying what is the willfulness that is causing you the harm?
Your Honor, this is the willfulness. When they decided not to do the search that would have actually disclosed for them that there were communications, that was willful. Their willful violation of 16.1, simply as identification of witnesses, was willful. And they stood upon that ignorance as a sword in terms of their motion of summary judgment to our detriment and for punitives, and they used it as a shield when it came to our motions Our other motion, John, if you look at what I've just got sticky, Your Honor, we actually found, Mr. Peppermint found a special master order regarding 16.1 productions from the special master here. And it is dated in 21, Your Honor, and it says it applies to all cases. So it's nothing different than what you said before. And 16.1, the violations they committed under 16.1, Your Honor, under the special master order, under the consolidated case order, there is and satisfies the willfulness prong under Young versus Johnny Ribeiro. Your Honor, you cannot sit upon false declarations and depositions because you failed to comply with 16.1 in the first place. If they had done what was required under the consolidated discovery order, they would have preserved the documents, they would have seen these witnesses, they would have known their communications, and they would not have submitted false declarations time after time after time. And remember, they use them in their motions as a sword, and they use them against our motion as a shield. That is the detriment to the plaintiff.
We asked for two different relief requests. One was to strike the answer. The other was to find, and you can phrase how you want to do your finding of punitive damages. I don't see any case law, let's go the alternative relief, right? That somehow this court can say on a clear and convincing standard has been met to reach punitive damages, because that would show, right, it's a different standard for the underlying facts. So how are you saying pre-trial, without a single witness on the stand, that the court can issue as a sanction, in essence, a finding that punitive damages would be appropriate?
And that's why you see in our reply brief, Your Honor, we simply striking the answer, because that's what the case law supports. I cannot find, and I will tell you, that's a very difficult question to answer intellectually, because mechanically it poses some problems. You'd have to figure it out. One way you could do it is if you
It's
could,
no longer your reply, so I don't have to address
Clear.
it.
our reply simply asks for what the case law supports, Your Honor. And again, I don't think, looking at the Young Ribeiro factor, John, and looking at the violations in comparison to the cases we've cited, I don't see where the court has, I think the court would be certainly well supported in striking the answer. Unless the court has any other questions.
No, I don't. Let's go here, and I'm gonna have to consider something else. Give me 1 second, I'll get the court's first order. Okay, I am correct, I knew the right funds. Mr. Waite, you may or may not have been familiar with it, and that's why the court pulled its first order. Is the court did already find that there was a violation of 16.1 and tied to 26. It's page 6 of the court's prior order.
Which order was that, Your Honor?
Court's order dated 1/17/2024 on the initial motion. And court, page paragraph 26, the court finds there are violations of NRCP 16.1 that are tied into NRCP 26, including the failure to provide documentation, the failure to provide notice of witnesses under those rules, okay? Actually, there's a technical typo, it says those rule, but the S, okay, don't think it would make an issue out of the S in there. And the citation 237, 16.1, E3 is in the conclusions of law on page 5, and the court addressed all of those, which is part of where my question was coming beforehand. So, in that one, that's how the BMX video came into first place, was coming into case already. And Anthony Randolph was going to testify at the time of trial, was testifying live, then he can address the objections. That was the deposition that was addressed, that was untimely, that was coming in. Then the monetary sanctions, and then the curative statement. The parties were requested for the parties being able to draft a statement for the court to review. So the challenge here is, I have, it's not a, the court has already ruled, when we just found out about the quote coupon that's late, and already issued sanctions relating thereto. This is now 290 new pages of problems. And I remember this order was done, but the hearing was back on December 20th. We had a whole couple of nice weeks of hearings, and so I remember exactly what day this one of the multi-days that you all spent here. And so all the pleadings were done in preparation for that motion. I will tell you, it's inconceivable to this court that no one checked to ensure that the representations made, i.e. the November declarations, were accurate when submitted to the court. And then after the court made his ruling in preparation for that hearing, that nobody went and triple checked, and particularly, Mr. Sexton's testimony, 30-year professional, worked for the Department of Defense, and then acknowledges this is the standard Microsoft suite, which has its own folder for archives, unless it was turned off. It's right there. You can hop on your own Outlooks and see it in the left-hand corner. In most versions of Outlook, there's a folder unless it gets turned off, right, or changed. But even not taking that into account, he said it was the standard Microsoft Office suite. So to say a 30-year professional didn't check to see if there was archived documents when the scope of the request goes back to 2018, and the request for the interrogatories back in 2022, which wasn't him, it's somebody we haven't heard from. But nobody's even stated that that person has done a full and diligent aspect that gave Mr. Kemper the true ability to verify interrogatories. I will tell you, I found Mr. Kemper credible. I found an issue there. I think he was given correct information, but it really is inconceivable that for purposes of trial, you don't go and look. And the problem is when you do a search, and this is where the ESI, the court asked the ESI issue, is you come up with search terms, okay? It's also inconceivable that if you have a search term, real water, that you wouldn't have come up with any of these documents. Because it's inconceivable, because if you came up with it for drinkrealwater.com, that subsumes the concept real and water is in there. So if you had done a real and you'd done a water, that's just, under the affirmative obligation to put documents into the repository under Judge Al's coordination of discovery order. You're not even relying on that, but that's an additional issue. It's inconceivable to say that couldn't find any documents. And then when you get to, and I appreciate this was argued to me at the first motion as well, that if there was one thing on pump, not to go back and check. And then how can a person who is not a chief information officer with 30 years can go, because if they can go on their web, right, saying they researched it by just doing web, it's a web search. That means you just click it on, and that's just a different method to get on to the Microsoft Office suite, is whether you're doing it directly through a computer that is a PC or a Mac, or you do it through a web-based program. She did it so easily. And so therein lies a very large challenge for this case from a credibility standpoint, that either the former director or the current chief information officer did not find anything. Now, with regards to the other individuals, they're not IT, but Mr. Breeden testified that he had Mr. Sexton come in and help him because he wanted to check different things. That's just, but he didn't know enough to check archives? By definition, your archives, right, the common plain English of the archive is you archive things after a certain amount of time because you're not having it readily available. That's just beyond reasonable. So then I have to go, is that such gross negligence, or does that fall into willfulness? And then I have to look at the ideas, is it to gain, right, some type of advantage in litigation? Well, since part of the issue is how much Terrible Herbst knew and what is the actual relationship between real water and Terrible Herbst, this court's hard pressed to say that the inexorable zero is an easy answer. Look, you know, and I appreciate, I'm not faulting Ms. Rojas, she didn't know about the documents from what the court had been provided, or any of the other counsel or ETT, but it's been all the, it's not us, all we did is we sold some bottles, we didn't say we'll sell the big jugs to Mr. Hunwardsen, okay? We're just a retailer, we just got these and, you know, put them on the shelf and we immediately did the recall. There's no relationship between us and real water, no, we weren't promoting it, no, we weren't doing anything till the November hearing, the November pleadings, which was the December hearing. And now, those emails show that there is a pattern over several years. And regardless of a conceptual idea on an individual case for 16.1, it's hard to say that that wouldn't be a litigation advantage to ETT because it's the theory that they've been going through. And I appreciate why they've been doing it because, like I said, Mr. Boho, you're brand new, so I sure know that you didn't know about this stuff, but okay. It's, therein lies the challenge for this court, is that how you could possibly say that when there was zero communications from all the people who were in charge of the very promotions and products, and a chief information officer, I go back to the fact that he said he has 30 years of experience with the DOD, with all sorts of different things, and has done these type of requests before, to have not checked the archive or thought that he should do some type of follow-up, just makes it look like something's being hidden. Now, does it rise to the level of willfulness for purposes of striking the answer? Well, therein lies an interesting question. And what is left of the answer to strike? Only the affirmative defenses with regards to compensatory damages and punitive damages. In essence, that's what's left. And the court can't go that far. It's the realistic aspect. I can't with the punitive damages case with clear and convincing evidence that actually has to be shown at trial in order to do it. But I can't strike defenses to punitive damages. I don't see that there's really support in the case law on that. Realistically, when you look at the answers that are stricken, they really go to the liability and causation components. They don't go specifically to the amount of damages, which is where you're at here. I don't see there's an affirmative defense as to the amount of damages, so that doesn't get you anywhere. It really just goes to the defenses and whether or not you can defend against punitive damages. And there isn't any case law that's been presented to this court. The defense to punitive damages technically can be stricken under a clear and convincing standard when there's been absolutely no testimony or evidence. So really the court's got to fashion a different remedy. And the question becomes, what is that remedy? Because the court's already fashioned one with regards to some, and now this is 290 times worse. Or maybe it's not 290, nobody's shown that there's any email within those documentations that does not specifically relate, so it's some number worse, up to 290 times worse. And counsel for plaintiff is not asking me to continue the trial and charge it all to ETT, is that correct? That's not your request?
That is not the request from the trial.
Okay. And so I'm not going to disadvantage them when you all done it. We've already got a jury picked. I mean, the amount of time and effort that was put into that, plus I have to, that would impact real water. Real water's not part of this. I can't do that to real water. I have to take that into account. So I can't, like, you know, basically say, guess what, the trial's not going forward, and guess what, you have to pay damages because of the real water component, okay? That would be, I don't hear real water asking me to do that, so,
We're not asking that, Your Honor.
so, I can't negatively impact real water when they're not a part of this motion. So I have to think of something that takes into account the egregiousness of the conduct, as something short of striking the answer. So I'm gonna let you all ponder that over the evening and tell me first thing in the morning tomorrow what you all are thinking would be appropriate alternative remedies. I think that gives each side an opportunity to know where I'm going. It's gonna need to be severe in light of what's happened. It's gonna be something short of striking the answer. It's not gonna be awarding punitive damages because I don't see the case. Well, A, it was withdrawn the reply, so I don't have to address it, but even if it was potentially re-brought up in oral argument, I can't still address it because of the prima convincing component. So I think the fair thing to do is give you each the evening to think about it. A, you might come to some kind of agreement. There's always rosy-colored glasses. B, the more likely thing is you're each gonna propose what you think the remedy should be. The court's gonna take that into account. Counsel for plaintiff, it's your motion, go ahead. You wanna say something? It's
Mr.
5:15, so I've gotta keep you short.
Yeah, this is not an argument, Your Honor, just a thought to put on the court's mind, perhaps, on
Bless
on
you.
opposing counsel's mind. A determination as to compensatory allowing the punitive damage to go forward. That way it's consistent. I see where the court's head is in terms of the other cases. Those other cases didn't have a punitive component. So they would not be able to defend against the compensatory part of the case. Now, the only case that came close was CCSD because there was a breach of the covenant of good faith and fair dealing in that case, you probably remember. But that's as close as I think you can come. But that would be the something less than striking the answer, Your Honor, or finding.
Since I said I needed everyone in the evening to think about it and see if you all want to talk among each other, that's what we need to.
Thank you.
And we address that, add it to our first thing list, okay? So I've given you part of the court's ruling. I'm deferring the actual sanction component until tomorrow, giving everyone additional opportunity to try to agree among themselves. We're going to come to an agreement, come up with some thoughts, because it's important. And it's not going to be re-arguing the merits of what the court's ruling. It's just going to be person A is requesting A, person B, or, defendant B is requesting something different.
Sounds great, Your Honor.
Okay, thank you so very much, folks. Good evening. Please, by the time, please do clear up things quickly and
Your Honor,
on the record. Thanks.
Can I just ask a question?
Hold on just a second.
You told the jury to come back tomorrow.
Guys, can everybody stop for just a second, so I can
We can't have somebody pack, I appreciate you starting to pack up, but then Mr. Waite wanted a question.
In light of your ruling, the jury's coming back at 10 tomorrow. Are we coming back earlier?
You don't have to.
Oh, we're done with it.
No, she doesn't. She told the jury to come back at 10.
I did.
I thought the thing she said everyone would come back. I could be wrong.
No, what Mr. Waite is saying is if you are going to present something if you're going to present something to the court, then if I need to hear it, I need to hear it before the jury comes back at 10.
So they're
Whether or not
not
I'll be able to take the matter before 10 in light of the rest of my caseload, I don't know. But yes, please be here if you wish to provide an option. If people don't wish to be here to provide an option, I will only be able to listen to the options that they hear. And anything else that the court is going to on its own consider as different.
We'll be here whatever time you would like us to be here. It just
Right.
seems that it would not make sense to have the jury waiting.
We can't communicate with the jury right now. I can't. Who would be the person who would be contacting the jury after the 5 o'clock hour? Jury services is left.
Yeah.
I mean, so they're gonna have to wait a few moments. Realistically, I don't see it being very long for you all just saying, plaintiff is proposing X. They've already told you what their proposal is. They might come up with an additional one tomorrow. Defendant, you're gonna have your proposal as something different that the court should consider. I really see that as a few minutes on each side, just saying your proposal, and the court's going to evaluate it. I do not see that it impacts opening statements at this juncture, but I don't know, maybe somebody's gonna say they want something in opening statements, so that's the reason why I'm doing it before. Nobody's saying the case that needs to be addressed there. But once again, I don't know what you're each going to specifically propose,
We'll talk.
okay? I'm giving everyone a chance to talk, address those issues. As far as the timing, yes, it would make more sense if you got here around 9:30. whether I can take it or not, in light of all the other matters, including another evidentiary hearing.
We'll be here then at least by 9:30, just in case.
Appreciate it. Thank you so very much, everyone. Have a wonderful evening.
You too, Yoda. Thank you.
Thank you.